right, here we are with DTLA. Here comes the judge with the awesome, wonderful, luminous jurist, Judge Veretta Frazier of the 44th District Court. How are you, Judge?
I am fantastic. I've got a jury deliberating right now.
Ooh, fun. Well, I will try to keep our questions short and concise. So if they come in, we'll get you out of here. Okay.
That's good.
Well, okay, Judge. Well, I'm going to just jump right into it. So, what are some of the things that you see the best lawyers doing in your court?
Some of the things that I see the best lawyers do is they will come with cases that they are really relying on or they really want me to pay attention to. I want those cases highlighted. Also, the movement providing a binder with all of the pleadings, like the motion, the response, and any reply briefing, and along with any of the cases, not necessarily all of the exhibits that are attached because I have that electronically, but I am definitely one of the judges that do like paper binders.
Gotcha.
And then also coming to the hearing with an order that you want me to sign, print it out. So just one copy is all that's necessary. Just bring up, each side can bring a copy of the order that they want. And that way I can sign it at the end of the hearing and we're done. I do not have electronic signatures.
Oh, I got you.
So I know a lot of my colleagues do utilize the electronic signatures. I don't. So you don't bring me a paper order, then I've got to print one out. It's more efficient if you just bring one.
So okay, so I just want to make sure I've got it down here. So the binder with the pleadings, your whatever your motion is, the replies, and the highlighted cases. That's
you really want me to focus on.
Okay, you really want you to focus on. Okay, so that makes perfect sense. And so so the flip side of that, what are some of your biggest pet peeves when people come into your court?
When we're starting trial, I specifically request that the lawyers do a joint working draft of the jury charge. I like to see that day one, like even during pretrial. I like to see one copy, not two. I don't like plaintiffs to send me a copy and the defendant. If the plaintiff could just initiate the jury charge, send it over to defendant redline it, put in what you want to be taken out, and like cross through it, put in what you want taken out, and then add in language that you want. One copy is easier for us to work with. And then as we're going through the trial, we'll have informal charge conference, obviously the formal charge conference. But that's the biggest pet peeve I have is wasting the jury's time when we can work on the jury charge more efficiently prior to trial, and then we'll lay down as trial goes along.
Oh, I got you. Okay, that makes perfect sense. So for you, it's just being protective of your juries.
Yes, and then also alongside with that is protective of the court staff. So clerks, when I hear about lawyers yelling at clerks or being rude or disrespectful to the court reporter or the court coordinator, that's another huge pet peeve.
I can tell you the fastest way to get fired at Hamilton Wingo is to be rude to staff.
And it should be. And
yeah.
That must be unacceptable.
Yeah. I mean, yeah, just general in life.
Right. Exactly.
Like those jerks that are like mean to like waiters. Like, no, can't do this.
Exactly.
Okay, so probably the biggest burning question for most lawyers in practicing in the court is, for you, what is the proper procedure and way to get hearings in your court?
Proper procedure, procedurally, call the clerk, right? I think right now we're on a 4-month delay. So if you want to get a hearing, it may take 4 months before it can get set. I am really working hard to make the court as successful as possible. We have a fantastic new associate judge, Judge Craig. You can certainly submit hearings before her that don't require a record because she doesn't have a court reporter. But also there are several things that I'm sending to her routinely that she hears. We're doing any continuances that are less than 2 years old. Damage prove-up cases only, not minor prove-ups, but prove-ups involving damages. Structured settlements, those are going to be shifted over to Judge Craig. And then any motions to reinstate, those will be heard before Judge Craig. So hopefully you'll be able to get those heard much more quickly than, waiting 4 months.
So continuances under 2 years, structured settlements,
Damage prove-ups.
okay, damage prove-ups. Okay.
And then a motion to reinstate. So you may know, if you've appeared before the 44th, we have a weekly status conference. And so sometimes there are DWOPs because plaintiff doesn't appear for the status conference for whatever reason. So those will be scheduled in front of Judge Craig as well, moving forward.
Okay. That makes sense.
Also, we have Judge Murphy, who will by submission hear motions for default judgment, and she does all of the rulings on subserve, motions for substitute service.
And so, so she's doing, so Judge Murphy's doing subservice ones and then submission motions for,
Default
Okay.
judgment. Motion for default judgment.
okay, motions for default. Okay, that's actually really good to know. Now, I don't know Judge Murphy.
Judge Murphy, she presided in the 14th District Court.
Oh,
She's a retired judge. She was one of the shareholders at Jenkins and Gilchrist when I was a young associate. So she was one of my mentors that I had the amazing opportunity to work with as an associate at Jenkins and Gilchrist.
that's awesome. Okay, and so she is a visiting judge.
Yes.
Okay, I got you. And then switching gears a little bit, discovery disputes. That's some of the meat and potatoes of litigation practice. And I find that judges kind of have different preferences a little bit on how these things are presented to them and how they like to see motions to compel in your court. What are some hallmarks of successful motions to compel in the 44th District Court?
So I like to hear the discovery disputes because I'd like to know where the case is. And so by the time it reaches trial, I'm familiar with the case as well. So I do try to have most of the discovery disputes set before me. I don't really have a preference. It's more expeditious if you have an order set out so that I can just kind of check what rulings I'm making. So that is
So a checklist order?
A checklist order. Again, paper orders are everything for me. If you have a small dispute, I really like, you don't need a binder, but I do like for you to have something specific. So if you have an order that just says everything is overruled, that's not really going to be helpful because more than likely, everything is not going to be overruled or granted. We'll probably go through and make specific rulings. So something more detailed in terms of the order is helpful.
Okay. What are when you are in these kind of discovery disputes, what are some red flags to you that someone's abusing the process some?
Honestly, nothing comes to mind. I really haven't had anything come before me that has presented that issue yet. But I'll start looking for it.
Well, that's good. All right, well, let's see here. Kind of tooting along here. Kind of getting into trial practice. What are what are your kind of your general protocols for how long do you give for voir dire, openings and closings and stuff like that?
I like to, during pretrial, I will ask the attorneys, what is your preference? How much time do you want? And I will probably give the plaintiff, if the plaintiff is asking for 45 minutes and the defense is only asking for 30 minutes, I will probably give the plaintiff's attorney the 45 minutes and also give defense counsel 45 minutes as well. So I try to give you for voir dire what you're asking for. I don't have a set time limit that I use for particular cases. So I try to give you what you ask for within reason. So if you've got a 1-day trial, I'm probably not going to agree that you should have a 2-hour voir dire, but I will say since taking the bench, most attorneys have been extremely reasonable. Most attorneys have requested sufficient time and usually come in under the time that they've requested. There's very few circumstances where I've had to cut someone off. So I think that my approach so far has been working, and the attorneys have all been respectful and have used it efficiently.
Okay, great. So I'm assuming that's probably the same kind of thing that you're doing for openings and closings as well.
You let me know what you want, and I'm not going to give you a minute over that time. I do keep time, but you let me know what you want, and I try to give you what you request within reason.
Okay, but you don't go over the time.
Will not go over the time. You cannot ask for additional time in the middle of your argument unless you are the plaintiff, where you have some additional time reserved in rebuttal, and you want some of that time, I'll let you do that.
Okay. And then so just for you, are there any other kind of specific other kind of court protocols that you like or important for your court or staff?
Not really. So I know I feel like I've made it an emphasis that I like paper and to give me binders. If you've just got a 2-page motion, don't give me a binder for that. If you've got a motion that is several pages and is tabbed off, then I will probably need a binder for something like that. And then just stick your order in the front cover of the binder. That's always very helpful. It's always very helpful to have it in anything you want me to review. If you file it the day before, it's not going to make it to Odyssey. I will not be able to look at it before the hearing anyway.
Oh, so yeah. So how long before the hearing do you like the binders to be there?
The binders and any filings that you want me to look at before the hearing probably should be here at least 2 days before the hearing. At least 2 days before the hearing. People have come quite frequently saying, hey, I filed this reply brief last night at 10 o'clock. The hearing is at 8:30 in the morning. It is not in my queue. I have not had a chance to consider that. So just keep that in mind.
Okay. I guess, and just lastly, what are some practice tips you would recommend for young lawyers practicing in your court?
Get as much experience as you can before the court. Ask to argue hearings before the court. Go and look at experienced lawyers try cases. As much as you can, go and observe voir dire. Just go see. I will absolutely make room in my court for any young lawyer to come in and observe any portion of the trial. I cannot express how valuable of an experience it is to watch lawyers, good and bad, practice their craft, because you can get something from everyone. So I would advise you to go, and if you want to be a trial lawyer, watch the great ones and go in and watch as much as you can. And then really advocate for an opportunity to argue hearings and argue things before the court as much as possible.
All right. Well, that's all the questions I have, Judge. I really appreciate you taking time out and hopefully the jury comes back, with the right decision.
Well, whatever their decision is the right decision.
Absolutely. All right. Well, thank you so much for your time today, Judge.
Thank you so much. Have a good afternoon.